Miscellaneous changes. We want to make several smaller changes to streamline and simplify the system. Prohibited emblems. There are emblems, such as flags, coat of arms, or international organisation emblems that cannot be protected as designs. Some of them are listed in designs law, but some are in other pieces of law. We want to introduce a provision in design law which clarifies that a design can be refused in this situation. Time periods for responses. At the moment, there are different periods, 2 months and 3 months, for responding to different types of objections the IPO can make to a design application. This makes the process more complicated than it needs to be. We want to introduce a single response period of 2 months. Applicants will be able to request additional time if they need it. Removing the ability to file specimens. It's currently possible to file physical specimens as part of a design application, and the IPO is required to store the specimen indefinitely. As very few applicants file specimens, we'd like to stop accepting them. Sharing applications before publication. Currently, the IPO doesn't share applications with anyone before publication. We want to change this for specific situations, like sharing coats of arms with applications with heraldic authorities or getting text translations. Powers for late objections. If we introduce the opposition period mentioned in Section A, we also need to make a change to the law to allow the IPO to be able to raise objections based on the information. Warrant of validity and liability. It's not possible for the IPO to guarantee the validity of any registered IP rights. This is because, even where a search is done, it's not possible to find everything which exists which might be relevant to the application being considered. To recognise this, patent and trademark law limit the IPO's liability in this area. We want to change the law so the same limitation applies to designs. Rectification of the register. Currently, if there's an error in the register, an application needs to be made to the court to rectify it. We want to allow requests for rectification to be made to the registrar or the court. This will provide a more accessible route for rectification. Updating provisions relating to inspections of designs. We want to update the law to reflect that information about currently registered designs should be viewable online, and the journal should provide a record of information about designs that have been registered. There are various forms which the public can use to make requests to the IPO. From time to time we update these forms, for example, to make sure they are clear. We propose to give the IPO broader power to update these forms. This will make it quicker and easier for us to make improvements to all types of designs forms. Priority claims. Applicants can file an application for a registered design in one country. If they file an equivalent application in another country within 6 months, the later application can keep the filing or priority date of the earlier application. We want to simplify the system for users. We're considering 3 options. Keep the current system, simplify it by only requiring basic details, or require details plus documents through a new digital system. For full details and to have your say, please continue to the consultation.